Good afternoon, everybody. This is attorney Irene Weisman. Today is Monday, March 3rd, 2025. I hope everybody is doing well. Today I wanted to discuss additional news that's happening in the realm of immigration law. So we've got word, okay, of a new policy. In reality, it's not really a new policy. Given this time, it's new policy. But, I've been in practice for over 20 years. This policy has been on the books before. I believe this was the Bush administration, at least the Bush administration, when we had this on the books. And the policy has to do with the issuance of notices to appear. What is a notice to appear? A notice to appear is the charging document that lets a non-immigrant know that they have to be in immigration court, that they are being placed in removal proceedings and have to show up in immigration court. I'm pretty sure I have a segment on the notices to appear somewhere in my line of of the videos that I put out. So let's talk about the new procedures that DHS is stating under which circumstances they will start issuing the notices to appear, placing people in removal proceedings, okay, which are, removal proceedings is deportation, immigration court, okay? So what are the instances? When, if a person applied for any immigration benefit, okay, such as a green card, okay, or temporary protective status, removal of conditions, okay, and that benefit was denied by USCIS, okay, and the non-immigrant is not in a lawful non-immigrant status or immigrant status, then that person is going to be placed in removal proceedings, okay? So for example, I'm gonna, try to simplify it. I'll attempt to. You came into the country with a visa 10 years ago, never did anything, never been arrested, nothing. Last year you met your spouse happens to be a US citizen, great, you're eligible, you get all documents together, you fill out all paperwork, and you sign everything and you submit everything to to USCIS for adjudication. For one reason or another, that application gets denied. Look, things can happen, right? A denial can happen for many reasons. They didn't believe the marriage was real, you didn't receive a notice, and maybe they sent you a request for evidence and you didn't receive it and the case was denied, or maybe you did receive it or you didn't respond, or you responded and they did not think it was adequate, okay? Case gets denied, okay? You don't have status. You stopped having status a long time ago. You've been here for 10 years, undocumented. You don't have status, a green card denied. They're gonna refer your case to immigration court, okay? Issue notice to appear, place you in removal proceedings, okay? Just one of the examples. The troubling, that hasn't been the case, by the way, in a really long time. A denial of a green card really has not triggered a notice to appear in a very long time. So we're going back, like 18, 19, 20 years ago. With 751s, that has sort of always been the case, but that has been like a hit or miss. I've had cases where, 751 was denied. They would issue a notice to appear normally, but it didn't always land in immigration court, because remember, not only does the government have to issue the notice to appear, they also have to serve it on the immigration court to properly place an individual in removal proceedings. But typically, a denial of a 751, remember 751 is an application to remove conditions on your green card. So when you have a 2-year card and you're applying to get the 10-year card, and for one reason or another that was denied, that denial typically triggered a referral to the immigration court, because you have lost your green card, you have lost your conditional permanent resident status, okay? So that would now trigger a notice to appear. If you applied for temporary protective status, TPS, and that was denied, they're saying that that would trigger an NTA. Something troubling in there that I saw, they're saying that if you had parole but your parole terminated, that would trigger the issuance of the notice to appear. So basically, at this point, with that, I'm getting this from an internal memorandum that came out. And basically what I'm getting is that, any termination of status or any denial of a benefit request, okay, would pretty much trigger the issuance of the notice to appear, okay? So just got to be more careful when you're doing things. Again, think about working with an attorney when you're submitting documents, when if you did it by yourself but you received a request for evidence, when they schedule you for an interview. Just think about being protected by working with a qualified, licensed immigration attorney to protect yourself, basically, okay? Now, occasionally you work with an attorney, but things happen, right? Especially with the non-receipt of notices. Unfortunately, that can happen. Usually there is a dual layer of protection. The attorney would receive notice, you would receive notice, but sometimes nobody receives notice. Okay, sometimes that happens. Usually there are ways to salvage, the situation, but it's, very unpleasant, okay, situation to be in, but unfortunately that can happen, okay? So just, be aware that we are getting into that territory that's happening, and you may invest in, even you think that, oh, well, my marriage is real, I really live with my spouse, we love each other, what should we be worried about? Well, even more the case to hire an attorney and to make sure that everything is properly done by somebody who knows, hopefully, what they're doing, okay? I think that's it for today. Be aware that that's the new policy, and talk to you soon.